The Valley Current.
Hi, Jack. How you doing?
Pretty good. Yourself?
Not bad.
I like what you got in the background there. You look like you're ready to do some big hiking.
I used to go up there every summer. Not anymore.
You're a big
Eastern
hiker.
Sierra.
You're a big hiker. I mean, you do a lot of hiking, don't you?
Well, I used to do a lot of fishing and hiking. Yeah, up in that's in the Eastern Sierra, south of Mammoth. It's wonderful, and I haven't been up there in a while. How you doing?
I'm good. I wanted to get you on because I think we should celebrate your 60th anniversary of practice as a member in good standing forever of the California Bar. And you've got such a great history. And I really felt this was important because I remember reading your stuff in law school. When I was at UCLA Law School, the guy who did the clinical class, I think his name was Leon Letwin. He was a criminal defense lawyer, but he did the civil advocacy class. He was a very funny guy, very entertaining. But he used your book about briefing. It was like this little tiny green pamphlet book that was like 50 pages or 70 pages. I think I have that book somewhere. I can't put my finger on it, but it's around. I remember reading Myron Moskovitz. I said, man, the guy's got a great name for an appellate lawyer, too.
I forgot about that book. It was a little dark blue book. I think it was called Winning an Appeal.
Yeah, it was great.
And I wrote it for mainly for my students and for new lawyers who were just getting used to the appellate process. It was kind of a primer. And I've gone beyond that. Now I've written some books that are more sophisticated for people like you who are already doing appellate practice. So I kind of covered it on both ends.
You have such a great history because I do remember then the other thing, just to tell you, my first contact with you was through your book. And then I did a little pro bono work in my second year, which was considered advanced. I worked in a clinic that did unlawful detainer defense. And you had a booklet about that. And you had a book or a booklet about defense to unlawful detainer and landlord-tenant cases, because we represented a lot of poor people in the clinics.
Well, I wrote that when I was at the National Housing Law Project at Bowles Hall. They gotten a grant from the poverty program to help legal services attorneys in housing cases. So I didn't know anything about landlord-tenant law, so I kind of taught myself, and then I saw a gap. There was a need for a book like that to tell people how to handle unlawful detainer cases from the tenant's end. And then to get it published, we didn't have that much funding. I didn't want to make a big deal, so I went to CEB. And I said, I got this book, and well, we don't do outside books, they said. We do our own work. I said, well, take a look at it. And they looked at it, and they liked it. And they said, well, we don't have any royalty program or anything. I said, I don't want any money. I want 400 copies free. So we have 400 legal services attorneys in California, and I want each one to get a free copy. And they agreed. And they made a lot of money selling the book to landlords attorneys because they wanted to see what was coming.
Right.
It's still, they still publish it now. God, it's been about 50 years, I think. So,
I think it was great. And it was like, to me, it was like, wow, this guy's got range. I mean, this guy's doing appellate stuff. He's doing landlord-tenant stuff. And I said, I hope I meet him. I remember in law school. So we're talking like, God, 50 years ago? It was so long ago. It's so hard to remember. I think it was 50 years ago.
Well, I'll tell you how I got into that kind of mentality where I deal with a lot of different things. After I finished law school, I was fortunate to get a law clerkship with Ray Peters on the California Supreme Court.
Great justice.
And, in law school, you get all these different courses. And then when people get out in practice, they all specialize, most of them, unless you're in a small town.
Right.
And one guy's in aviation law, another in car accidents, another in probate. And when I was clerking on the Supreme Court, I would get 2 petitions for review every week. And every one was on something I never heard of. I think my first one was on the Harbor Navigations Code that California has. I never heard of it. And I got 3 days to learn that area of the law, read the petition and the opposition, and write a memo to the court recommending either grant or denial. So bang, bang, bang. Every week it was 2 of these, and none of them were about something I learned in law school. They're all about something weird. And I kind of got used to the variety, and I liked it. And that's actually what I like about appellate law. And yes, I suppose I'm an expert in appellate process, but on the substantive law, I cover everything. I've had cases. I had one for a ballerina. I won recently for a minor league baseball team owner. They're all over the lot, and it's fun. Most people don't like that. It's hard to learn something new every time, but I enjoy that.
No, I think it's a worthy thing to have range. And if you look at actors and actresses that have range, they have range where they can be funny, they can be dramatic. Yeah. I remember, just to tell you my story, when I clerked, and I remember doing this, it was on the 2nd District Court of Appeal, and the guy's name was Justice Potter, Sidney Potter, and really smart guy, had been a partner at Morrison and Forster, and then decided, I don't want to practice big law anymore. He went on the bench. He got appointed by, I wanted to say Jerry Brown, or maybe the father of Jerry Brown. I'm just trying to remember who was the governor then.
Pat Brown.
Was it Pat Brown? But anyway, the point is that he would give me these things, and he would say, one day it was like a criminal case, and the next day it was like, yeah, we're going to do the strict products liability of used products case, and there's no precedent on it. We're going to do a published opinion. And, when you get that inside view where you really understand how judges and justices look at cases on appeal, it gives you a huge advantage. And they are doing a wide range. They are doing
that's right.
a wide range.
That's right. They're generalists, so I got to be a generalist.
Right.
And you find the strategies on appeal are similar in all these cases. I get people who call me up and they say, have you ever handled a case dealing with prenuptial agreements? Because that's what we got.
Right.
I might say, I actually have, but I might say, no, I never have. But you're asking the wrong question. That doesn't matter. Right. I can learn that stuff in an hour or 2.
Right.
The question is whether you're experienced in dealing with appellate courts. That's what counts, not the substantive area.
Right.
And if you're a computer expert, right? I'm still getting used to indoor plumbing, so I'm nowhere near your level. If I get something
we're actually not that specialized compared to some lawyers, because I hear lawyers who say they focus on lemon law returns, returns of used cars.
Yeah, I know.
Used cars. I'm like, why don't you deal with all automotive issues? No. We just deal with lemon law returns.
Tiny niche. And they can make a living on it.
They do billboard ads. They do number ads at work.
I know. But anyway, when I get something where I think it's over my head, in terms of technical stuff, I bring in somebody like you, to help me out with that. But the key thing to focus on are the judges, right? Now, there's a handful of specialized courts in this country, the federal circuit, stuff like that. And I can't do that. I can't do patent law, right? But everything else, these judges are like me, except they wear a robe. They're generalists, and lots of times I get cases from lawyers who are really real specialists, and they talk in a language I can't understand. They use these words and concepts, and sometimes I feel like a translator.
Yeah.
Because I can't use their words with these judges. They never heard of them. So I got to translate it in English they can understand.
Right.
And I got to understand it to do that.
That's actually a value add because those lawyers will completely lose their audience in the first 5 pages of their brief.
Exactly.
They'll totally lose their audience.
Yeah, they don't realize that the people they're talking to are not their compatriots who speak on the same level.
So just tell us a little bit of how you went from the California Supreme Court to your first position, because ultimately you became a professor in San Francisco teaching law for a while, right? But that you practiced for a while.
For a long while. Well, funny, when I was clerking in the Supreme Court, I was living in Berkeley, and I was in a carpool with some other guys who lived in Berkeley and were commuting to the city. Several were law clerks, some work in the AG's office, and Jerry Brown was one of them because he was clerking for Trubriner when I was clerking for Peters. And these guys, most of them have gone to Eastern Ivy League schools. I went to public school all the way through, including both. These guys went to Yale and Harvard, and they were much better educated than I was. And
they were.
They were talking about one day it'd be Dostoevsky, and the next day the New Republic magazine. And I didn't know what the hell they were talking about. And I went home and I quickly tried to read this stuff to catch up with them. And it was a real education for me. So when I finished my clerkship, Lyndon Johnson was starting his anti-poverty program.
Right. Great society.
I wanted to help. So I went to Washington. I worked in the general counsel's office there. And I ended up helping CRLA, California Rural Legal Assistance, on a case where the Stanislaus County Bar Association was trying to kick them out for unfair competition. So I helped write an amicus brief. Then they asked me to run one of their offices up in Marysville, open the office and run it. And I did, representing mostly Mexican-American farm workers. It was great. I loved it. So I did that for a while, and then the dean at Bold Hall somehow knew I was in the poverty program, and they got this grant from the feds to deal with housing law. He said, "You want to be the chief attorney?" I said, "Sure." So I went back to Berkeley and did that for a while. And then one day I get a call from a guy named Roger Bernhardt, who was teaching.
I know Roger. He wrote the book about real estate security.
Yeah.
Trustees.
And he was teaching at Bold for a while, so I met him there. And he called me up and he said, "You want to teach law at Golden Gate?" And I said, "No, I'm too young for that. That's for old guys." And then he called me again, and he happened to catch me on a July summer day, and so I'm looking out the window, and I thought, God, if I was teaching now, I'd be fishing. And I said, I'll take it, because you don't work in the summer, and I thought that was great. Teaching, and that was okay, but I really liked the time off. So I ended up teaching there, and it gave me time to do some appeals on the side. So I kept my finger on that pot. And then about 9 years ago, I finally retired from teaching. And I figured, what the hell? I started a new law firm doing nothing but appeals. And while I was at Golden Gate, I had run a program holding moot courts for lawyers who had cases in the California Supreme Court. And I'd recruit some lawyers and retired judges to be on the panel, all free. I took them to lunch at a Chinese place, and it was great. I really had a good time. So when I retired, some of these judges I had known had retired, and I called them. I said, let's do some appeals.
Nice.
And I got 3 terrific judges, and they're still on my team. And that's all we do is civil appeals.
Right.
No criminal. And it's fun. We handle cases all over the state and federal. Got some cases in other states. Right now I got one in Hawaii, one in Ohio, and one in New York, and I got one coming up in Boston. So, with computers and the internet, I don't have to travel that much. Once in a while, but
right. Right. So you really did something that's very exceptional, which is you went from someone who was teaching law and practicing part-time appellate to doing full-time appellate, starting your own firm when most people would be retiring in their 60s. You were basically saying, I'm just getting restarted. You reinvented, hey, I'm going to do the Moskovitz appellate team, which is what your firm is now, right?
Right, yeah. Yeah, it was, I enjoy it. I like writing briefs. I like analyzing things. I work pretty fast, so I'm able to handle a number of cases. I usually have about a dozen going at one time in various stages. I got other people on my team that help me with the larger cases, and we have a very good success rate.
You got my quote on your new website. That
I do, Jack, and I really appreciate it.
Correct quote. Myron and his team of former appellate justices have more civil appellate talent than most law firms in California, if not nationally.
Thank you, Jack. I assume that's based on a wide survey, and it's factually accurate.
It's very accurate, because you have probably the best, most experienced civil group. And it's interesting because you don't really advertise or do much marketing. I mean, you're kind of like me. You let people come to you. And the truth is, they should come to you because you probably have the best pricing, because you're very efficient at what you do.
Yeah. Our prices end up being pretty reasonable because we work pretty fast. And these big law firms, you look at their briefs, they may have 5, 6, 7 people on there. We usually have 2. And we don't, the briefs are short, there's a 14,000 word limit, and most of my briefs are about half that, and judges like that. We get to the heart of it, get out, and save some arguments for the reply brief when I know the other guy's going to hit us on certain stuff. So it's worked out really well. And I think the experience of myself and these other people really make a difference. This guy you're showing on the left, Jason Marks, retired recently from the California Supreme Court. And, I clerked a long time ago. Things have changed since then. And when I get a case I'm thinking of taking to the Supreme Court, I ask Jason, what are those guys like?
Right.
What kind of cases are they willing to take? And he gives me some insights that are just invaluable.
So you've got some new people in addition to the retired judges. You've got Jason Marks and David Kaiser as well, right?
Yeah. David was on the clerk on the Supreme Court for a long time too. So it's very helpful to have that insight. And of course, I do some marketing. I speak to a lot of bar associations, CV programs, things like that. So I get out there. But it's, I have a very nice website. I got my judges in robes in the first picture, and this is unusual. If you look at other law firm websites, that they may proclaim they're great by talking about a few recent victories or old victories. I give them all. I give a summary of every appeal I've handled, winners and losers. And I figure people are entitled to see the whole thing, and the good stuff, the bad stuff, and the ultimate win rate for appellants for us is about 60%, around there.
Right.
Varies a little depending on what happened recently. The average reversal rate for all attorneys is about 17%. So we're kind of proud of that. That shows that we know what we're doing. We don't always win,
Right.
but and of course you have to consider the fact that I turn away a lot of cases. Over half of the people that call me, some lawyers take everything because it pays. I don't.
Right.
I'm not going to take people's money if I don't think they got a respectable chance of winning.
That's an important point because a lot of people want to believe that the odds are really good on appeal. And what we know is that the odds are never great on appeal.
They're terrible. They're terrible.
Right?
And the funny thing, it's consistent both in state and federal court, and it's consistent over the years. It's around 17, 18% that result in reversals in civil cases.
Right.
I think in criminal it's lower, but we're quite a bit above that.
Look at the history. You've put in now 60 years. I think your 60th year anniversary is coming up in the fall. I think you passed the bar in
1964. I think I was sworn in January 65 with.
Yeah, so you're coming up. You're coming up basically. You passed the bar in the summer of 64. They give you notice of it. It takes a while to go through a paperwork process, but basically, and you worked on the Supreme Court for what, a couple of years, even before taking the bar?
A little over a year.
Yeah, so you've been in for more than 60 years of actual practice, but from the bar registration point of view, it's 60 years. I think you're less than 1/10 of 1% of people that get to that point and stay as members of the bar, and they don't give up their license. Like they just basically, most people at certain age just give up their license. They just give up.
Yeah.
I don't think that's you. I think you're going to keep it, and you're going to keep it right up to the bitter end, I think, right?
I don't have any plans to quit. I don't work as many hours as I used to, but it's still pretty substantial. And I have time to play tennis. I got a 13-year-old son, and I play with him a lot, and baseball and tennis. And occasionally I have time to go up in the mountains. And I do some traveling. So, I do a lot of other stuff. So let me just ask you before we end, when you get a case that you like, because you typically take cases that you think you can win, and you like, got to be the right case, the right client, the right, facts, the right. Believe me, I used to think there was such a thing as a slam dunk. I've been disabused of that. Some of these judges have a different sense of justice than I do. So there's no slam dunks.
So when you decide to take a case, and obviously the client gets you the opinion or whatever the ruling was, or the verdict or whatever they get you, and then they start getting you more and more information. What is, like, do you meditate on the case? What is your style? Like, how do you conceptualize the approach? What do you do? Do you go for a hike? Do you play some tennis and think about it? Because I know you engage in some deep thought, and that's really what the client is paying for. They often
you're right, Jack.
That's
a terrific question. I mean, I've thought a lot about that, and this does not come from any plan. It just comes from my gut.
Right.
All right. I'm looking for a sense of injustice.
Right.
If I represent respondents too, but your question's about representing an appellant.
Right.
There's something wrong here in this case. This just isn't fair. It's not just a technical violation of some rule. I got a case right now. I can't really talk about the details, but the law firm that tried it was all into the technical rules of law.
Right.
I'm looking for a theme.
Right.
A theme of injustice that may bring into play 2 or 3 of the legal issues.
Right.
But there's something wrong here. This guy got screwed.
Right.
And that's what I build my brief on. And where do I get the idea? you're exactly right. I'll read some stuff, and then I'll go someplace in tennis, or I'll go swimming. And somehow the physical activity gets my mind bubbling, and that's where I get my best ideas.
Right.
And I happened to mention this to my wife once, and she's my business manager, and she says, well, of course, you're billing for that time, right?
You're not.
I said,
right?
What are you talking about? I'm swimming in the swimming pool. How can I bill for that time? She says, are you giving value to your client while you're swimming? I said, oh, yeah, I am. I mean, this was my best idea in the whole case. Then you're billing for it. and she was right, because the final result is so much better because I did that kind of thinking. And usually that kind of thinking sped things up because it gave me a focus to bring everything else into play, into that theme. And it made for a better product and a better value for the client. But that's the way it works. When I started out, like that book you mentioned, that little Winning an Appeal, it has a system, which I think most novices need. But I'm way past that now. I mean, so much of what I do is I can't even explain. I couldn't write a book telling people to do it the way I do it. It's intuitive at this point.
Well, I'm going to send you as a gift, because I think you'll like reading this. There's a book that just came out by Rick Rubin called The Creative Act, A Way of Being. It's actually got very high ratings. And the reason I'm going to send it to you is I'm going to send you the audio book because you can listen to it while you hike or something.
Yeah.
It's in his own voice. And what I think he's captured, and I'm not trying to sell books here for him, and I barely know the gentleman. I don't know him in person, but I know him from his work. He is kind of an expert on what makes rock bands successful. He's actually kind of a person that put the Beatles or helped the Beatles, helped the Rolling Stones. He's actually a very famous guy down in Los Angeles. But he wrote this book that's really a great work about what creates that creative spark. And the thesis of the book, which I won't reveal the entirety of it, but a big one is just exactly what you said, which is you have to spend time thinking and then accepting that the theme will come to you, because it always does eventually. It always does if you're experienced. And that's what experience and expertise really means. The theme will come to you because you've got so many brain connections that help you put something together in the best way you can put it together. And that's the creative act. And that's actually what clients are paying for, but they don't realize that they're paying for that and not just the actual paper that's pushed out the door. The paper is important, but it's that creative theme that you put together. And he really does a good job in this book explaining what it is and explaining the process that typically occurs among creative people. I think
Thank you, Jack. I will read that. But I do want to tell you the flip side of that.
Yeah.
And this is something I learned the hard way. And young attorneys don't know about this. They learn the hard way too. The hard way is losing a lot of cases. I've had cases where I am bang on right on the law, and the guy got screwed, but there's something about the guy, as disclosed by the record, that people don't like.
Right.
I call it the bad guy phenomenon. Right. I had one case, just to give you an example. My client was a deadbeat. He wouldn't pay his debts, and he pulled all kinds of shenanigans to avoid paying his debts. And the trial judge threw the book at him.
Right.
And let me tell you what I mean by that. He went around the book. There is a book. The civil code sets out certain remedies for people to do what my client did.
Right.
And this judge says, I don't care about those. I'm going to hammer them harder than that. It's like, in a criminal case, you got these sentencing guidelines, and the judge says, to hell with them. I'm sending this guy up for life.
Right.
And that's the example I used in my brief.
Right.
And appellate court didn't buy it. They screwed them the same way the trial court did.
Wow.
They didn't like them. And
Right.
that happens over and over. And, I write this column for the Daily Journal, and I was started writing one on this phenomenon. I did a little research, and lo and behold, I find a study done by some law professors and a federal magistrate. They went to a conference of a whole bunch of judges in New York. The conference is in New York, but these judges from all over the country in Canada, and they gave them a test. They gave them two hypotheticals. They both involved some pure issue of law. How do you interpret the statute? But the hypothetical facts in the two examples they gave were different.
Right.
One involved, I think it involved sneaking into the country from Mexico. One guy was coming in to get medicine for his very sick daughter, and the other guy was coming in as a hitman for the cartel to kill somebody.
Right.
But the legal issue was exactly the same. It had nothing to do with the facts. And guess what these two groups of judges did? One was 40% higher than the other.
Right.
On stuff that's irrelevant.
Right.
They were going to screw the bad guy and help the guy who's not very bad.
The bad guy phenomenon.
Yeah.
The bad guy phenomenon.
Some of them were appellate judges.
Right.
And I see this all the time. And I've seen it enough to tell people. I had a consultation with some lawyers today. They wanted me to know from me what I thought, whether they should appeal. And I told them, your legal issues aren't great. They're not terrible. But this judge said some very nasty things about you.
Right.
The appellate court's going to see that. You're dead.
Right.
That's the end of it.
Right.
This isn't my view of you, but it's going to be their view of you.
Right. Right.
And forget it. Don't do it.
Well, it's a little bit along the lines of many people don't know unless you've worked for an appellate judge or justice as you have and I have, that when a trial judge says, you lack credibility, sir, that's it. It's over. It is over and out.
That's in the record.
Signal to the court of appeal.
Yeah.
This guy was lying under oath.
Yeah.
And I'm just not taking it.
Yeah. So that
happened to Sam Bankman-Fried. That happened in the trial of Sam Bankman-Fried.
Yeah.
He was done. He was cooked. And the fact that they put him on the stand, probably knowing that this guy uses all sorts of bullshit all the time. I mean, we're not focusing on him, but it's a good example. Judge Kaplan threw the book at him and, actually gave him I thought the sentence would be far higher. I had a little bet going for a case of wine with someone who said, nah, it's not going to be that bad. And I said, no, it's going to be bad. It's going to be more than 25 years. And, he got 20 years. So I lost that bet. But I thought to myself, man, he made such a crucial mistake taking the stand and doing word salads that the judge had warned him multiple times he was never going to allow. And ultimately, I think the jury got the message as well. So,
I suspect it was his parents that had faith in him that made that happen.
It's stupid. I mean, it's really stupid because I think when that case gets decided by the Second Circuit, we're going to see some interesting language in that opinion. I know you just argued a case in the Second Circuit and we talked about it. We don't have time for it tonight. But in general, I think it's a good example of the signaling that judges have to send a message that, hey, look, I'm not going to deal with any of your nonsense. And a lot of clients don't appreciate it. It's not just showmanship. You really have to be honest and truthful. And if you're not, and the judge detects it, it's game over. Yeah, it really is.
No, I always frame it to the client. My view doesn't matter. It's the judges that count. And my experience tells me they're not going to like you at all.
Right.
I like you, but I don't count. It's them that counts.
It's like Joe Biden saying, sorry, I had a bad day. Well, you know what? America decided it was over.
That's right. That's right. They don't give you a second day.
Get him in. He had
That's your day.
Right?
Yeah.
That
So
one event.
the experience comes in handy on the upside and on the downside, you
Right.
know. And I think I end up saving a lot of people a lot of money and a lot of grief by telling them, don't appeal,
Right.
do something else.
Right. I agree. And I always get, when I have a client that can afford it, I always get a second opinion from Myron, and he is someone that will give a second opinion and do it right away. So for all the lawyers that are listening, Myron, how would they reach you? Because you pick up the phone directly when you get a call. I like that about you.
Yeah,
At least with me,
I
you do.
often do. I like talking to lawyers. Yeah, just give me a call. My phone number, 510-384-0354, or just go online and look me up, and you'll get my firm's website, and it has all the contact information and gives you a lot of information about the firm. So
Right.
you might find that helpful.
Well, thanks, Myron. Congratulations on your 60th year.
Thanks, Jack.
I hope you put in another 40.
Oh, I'm looking forward to it,
super
Jack.
centenarian.
keeps my mind busy, so I don't go senile.
Absolutely. I mean, look, your son will only be like 53 in 40 years, so it's okay. It's
Right,
okay,
yeah.
right?
Follow my footsteps.
Yeah, you need to get him to go to law school. That's absolutely a good idea. The more
I'll tell you. It's funny you mention that. He's just a little kid. He's 13 now, but I've been doing this since he was 7, 8 years old. I tell him about my cases. I
Right.
summarize it,
Right.
and I'm pretty good at explaining things in simple language. And I
Right.
tell him about it. I say, Ari, what do you think? How should the court rule? He zeroes in every time on the heart of the case, and
Really?
he gives the right answer.
That's huge.
So he's got the instinct.
You got to put him on the payroll. You got to put him on the payroll.
Quiet,
I'm
Jack.
serious.
You can hear it.
No,
They got enough
seriously. Wait,
expenses.
Myron, wait. This is a big idea. Your wife will love this because your wife gets the tax angle. Put him legitimately
So I
on
can
the
bill my
payroll.
clients for a 13-year-old's opinion.
No. The 13-year-old is just a little assistant to you, or a research assistant, and then you pay him whatever is the maximum amount that is not taxable but is deductible by you, and you put that money into a Roth IRA for him. And by the time he's 23, every year you invest in
All right, maybe I'll do it.
Do that. And by the time he's 23, in 10 years, he'll probably be a millionaire.
Okay.
I'm serious.
I also use them for, I think what everybody listening uses their 13-year-olds for, and that's getting them on the goddamn computer.
Exactly. No, I'm serious.
Zoom with you.
I'm serious. Your wife, I know she's tax savvy. She'll say that's brilliant. We should have done it like 10 years ago.
I'll do it, Jack. Good idea.
Tune in next time on The Valley Current.